Truth Espresso, episode 206.
In a world gone bonkers.
It is not, generally speaking, unruly, but fires have been started and...
Where the culture is a dumpster fire.
We're coming for your children.
And churches have lost their way.
I am really uncomfortable with the story of the crucifixion.
It's time to wake up with Truth Espresso.
Truth Espresso.
Your weekly shot of truth. And now your host, Daniel Minnick.
Hey there, friends, family, foes, and lurkers alike. This is your host, Daniel Minnick, with another episode of Truth Espresso and another part in the Manhattan Madness series. This is part 4. And as I was preparing notes for this episode, I really thought I was finally going to finish everything, but to do justice to the actual verdict, and because of all the details I need to get into with closing arguments in this case, well, I hope you enjoy this series on the New York Trump trial, because that means, for better or for worse, there will be a part 5. And so where did we last leave our heroes and our villains, whichever side you would attribute those titles to? In part 3 of this series, we talked about the prosecution testimonies, and the prosecution had quite a slate of witnesses. And so now we're going to get into defense testimonies, and then afterwards we'll look at the closing arguments from both sides. And so as we get into defense testimonies, before it seemed that Trump was planning to testify in his own defense. So Trump thought about taking the stand before. It seemed like it was originally going to be a far-gone conclusion that he would, and then he seemed to walk that back over time and then eventually decided not, because who knows, maybe his lawyers told him that it wouldn't be a good idea. Eventually, after some of the testimonies there, and Trump himself said that, they can ask you a lot about your past. And so take that how you will, but Trump figured, hey, whatever you say and do can be used against you in a court of law. And so in this court of law, he figured that as much as he might want to testify under oath, anything could be brought up against him from his past. And so then that statement, you also have to weigh whether Trump recognizes that some things that he did in his past he's not proud of as he's older, and maybe he's changed his outlook on life since he used to be a New York real estate mogul and star. But nevertheless, Trump decided that it was probably in his best interest not to take the stand in his own defense. So then we get into the non-Trump defense testimonies in this case. And as there were many prosecution witnesses, there were very few defense witnesses, as we shall see just how few there were. So on May 20th, Trump's defense expert witness Bradley Smith was a campaign finance law expert from the FEC. And at the heart of this case is the idea that Trump had violated FEC regulations, Federal Election Commission. And so who better to bring as a defense witness than someone who worked at the FEC and was an expert on understanding Federal Election Committee laws pertaining to campaign finance. So Bradley Smith was going to explain how the hush money agreements didn't, in fact, violate campaign finance laws, which he arguably understood in depth. However, Bradley Smith did not end up testifying. So why was that? Well, it was because Judge Merchan gutted what he could talk about. So Smith, who was an election law expert, could only testify about basics, as Judge Mershon said, of the FEC and, quote, general definitions and terms, unquote. But Smith could not elaborate any further on that. Why? Well, because it was Mershon's job to instruct the jury on matters of law. So we have someone who is an expert on the particular law at hand, but the judge said that he could not go into too much detail because Judge Mershon, as the judge of the court, had to be considered the expert on the law. Naturally, with such vague and uncertain limitations on what Bradley Smith could talk about, the defense decided not to call him as a witness. However, as Smith noted on X, formerly known as Twitter, since the judge didn't seem to have any problem with Cohen blabbing about election laws in his testimony, remember, Michael Cohen was the former Trump lawyer who the prosecution had as one of his star witnesses and had been convicted of lying under oath in court. But Smith said in his post on X that since the judge didn't seem to have any problem with Cohen blabbing about election laws in his testimony, that this meant the jury would get, quote, its instructions on FECA from Michael Cohen, exclamation point, unquote. So Bradley Smith, FEC expert, seemed to have a problem with Judge Mershon allowing Cohen to talk about election laws and how he believed that Trump violated them, but somehow an election law expert wasn't allowed to testify. And so, in a sense, the jury would only get its instructions on the campaign finance laws from Michael Cohen and ultimately from Judge Mershon, but not someone who's an expert in the area. And I'll provide a link to a Fox News article that discusses this in the show notes. So, also on May 20th, the first defense witness, since Bradley Smith could not be it, was Daniel Sitko, who was a paralegal for Trump's defense attorney Todd Blanche. And Sitko briefly testified and provided a chart of phone records between Michael Cohen and Robert Costello. And then this would lead to Costello being the second defense witness and the final defense witness. So Trump didn't testify. Bradley Smith, who was going to testify, felt that he couldn't because of a ruling from Judge Mershon about what he could and couldn't talk about. So ultimately, the first witness was just a paralegal very briefly and was leading up to the primary defense witness being Robert Costello later on in that day. So later on in May 20th, and then on the 21st, the defense's witness Robert Costello testified. Robert Costello was an associate of Michael Cohen by the recommendation of Rudy Giuliani. The prosecution and defense attorneys argued over what Costello could testify about before he testified. The defense seemed a little miffed about how the prosecution wanted to limit what their only real witness now could say. Judge Mershon said that he didn't want the testimony to be about vetting an alleged pressure campaign from Trump against Cohen because of outside legal issues over his real estate activities. So Cohen was convicted of tax fraud over several $1 million related to his real estate activities, and some of this came up in the cross-examination of Cohen, and so there's a dispute between the sides over how this would have to be talked about, and Judge Mershon said that he didn't want a trial within a trial. So when Costello finally went to the stand and was able to start testifying, he gave some details about how he had met Michael Cohen and how flustered he saw Cohen act when the FBI raided Cohen's home and office and hotel room in 2018 over the various charges that I had mentioned in a previous episode in this series. Some were related to the hush money payments, indeed, but likely most of the activities were related to the tax fraud charges within Cohen's taxi medallion business. Several times as Costello was relaying a detail, the prosecuting attorney said, "Objection," and Judge Mershon said, "Sustained." Eventually, this pattern of occurrence, making it hard for Costello to know what he was allowed to say, seemed to wear on him. At one point, he mumbled, "Ridiculous." Costello then claimed that Trump didn't know about the hush money payments and that Cohen had admitted this several times. Now, after some more series of objection and sustained occurrences, Judge Mershon told Costello that he had to refrain from giving his answers after the objections were sustained. After yet more of these, Costello continued to get annoyed, and he reflexively said, "Geez," a bit loudly. Judge Mershon replied, "I'm sorry," and Costello tried to quiet his frustration. A bit later, Judge Mershon ordered the jury to leave so that he could reprimand Costello. He said, quote, "If you don't like my ruling, you don't say geez," unquote, and that only he had the power to strike anything said in the court. He also said, quote, "You don't give me side eye and you don't roll your eyes," unquote. So apparently a frustrated Costello, after Judge Mershon would repeatedly sustain the prosecution's objections, he was probably getting a little frustrated and glaring out of the corner of his eye at Judge Mershon, and Mershon was not happy about that, and at some point he must have rolled his eyes, and that really was the straw that broke the camel's back, apparently. The judge warned Costello again not to continue answers after sustained objections. He then told all the reporters to leave the courtroom and told Costello, quote, "I'd like to discuss proper decorum in my courtroom. You don't give me side eye and you don't roll your eyes," unquote. He told Costello, quote, "I'm putting you on notice that your conduct is contemptuous. If you try to stare me down one more time, I will remove you from the stand," unquote. The judge then told the defense attorney that Costello's entire testimony was at risk of being stricken if he continued his negative conduct.
If the practice principle is vital for teaching such morally neutral task as tying shoes, how much more important is it for training children in Christ-like character?
This is Yvette Hampton, host of the Schoolhouse Rocked podcast. Join us each week for a new episode as we offer encouragement and resources on biblical discipleship from popular speakers and authors, as well as parents just like you and me. Find out more at schoolhouserocked.com or listen anywhere you find your favorite podcast.
After the reporters re-entered for the case to resume, it was time for cross-examination. The prosecution asked Costello if he wanted Cohen to hire him and if he considered it a big opportunity, and Costello affirmed. The prosecution asked Costello a little more about how he understood the FBI search on Cohen. The defense made a final motion to dismiss the case, claiming that the prosecution failed to prove that Trump had falsified business records. The judge would rule on that motion later. Cross-examination continued, and Costello explained when answering questions that he found Cohen to appear suicidal about the FBI search, and that he acted like a drama queen, in his words. After Costello's testimony, the defense rested their case. The judge and the attorneys discussed the motion to dismiss. Trump's lawyer, Todd Blanche, argued that Cohen's testimony is unreliable because Cohen is an admitted liar found guilty of perjury in a court of law. Judge Mershon wondered if Cohen could, quote, "fool 12 New Yorkers," unquote, of course referring to the jury there. Now, again, I am in no way arbitrating truth here, just giving details as I've researched them, but it's at least reasonable for someone to wonder about the bias of this judge. One of the star witnesses for the defense was a lawyer, yes, formerly Trump's lawyer, but someone who has been known to lie through his teeth with impunity under oath. And this is someone who's supposed to provide a reliable testimony for jurors to deliberate. Cohen was also the only witness whose testimony was relevant for linking the payments to Trump himself. Again, remember, the prosecution had multiple witnesses, quite a few, including one who is guilty of perjury, and the judge didn't seem to care. Yet the judge ruled in such a way that the defense had to forego their expert star witness. Then they ultimately had one primary witness who constantly had to endure sustained objections against what he said. Remember, the prosecution got to have a witness to shock the jury with unnecessary details about the alleged Stormy Daniels affair to pollute their view of the defendant, while the defense wasn't allowed to squeak out much of a case. It's understandable to think that this judge was biased. Again, I'm not making a legal declaration here, only an observation. You can take the details as you will, and do not make my episodes of Truth Espresso covering this case to be any kind of final ruling about the truth of this case. You could do the research yourself. So Judge Mershon limited what FEC expert Bradley Smith could say to the point where he had to bail out of testifying, because the judge could be the only expert on the law that the jury could hear, you see. I guess that's relatively common for what I've read, for the court to be the ultimate interpreter of law, but understand it's hard for the defense to mount a case that Trump was not guilty of an FEC violation when an FEC expert can't clarify the law to the jury. Then also, the judge pulled these hostile antics on the only substantial defense witness who remained. There's good reason for anyone sympathizing with the defense in this case to think something about it could have been rigged. Now, I'll provide a link to the show notes from NBC News that provided some of the details that I talked about here with the defense testimonies. And now, after the defense rested its case, we move on to closing arguments. So on Tuesday, May 28th, closing arguments happened. Todd Blanche, the attorney for the defense, emphasized that the jury deserves better than Michael Cohen's testimony. He stressed that the case is about documents and not to let the Stormy Daniels testimony and her details there distract them from what the case is actually about. The prosecution must prove their case beyond a reasonable doubt. And well, Truth Espresso friends, wokeness is everywhere. From kindergarten to elementary school to middle school to high school to higher education in most universities. It's all around us where we shop and where we work. It's even crept into many churches. Romans 12:2 says, "Be not conformed to this world, but be ye transformed by the renewing of your mind." So where can we go to get good, wholesome, encouraging, and in-depth materials to study the Bible and teach ourselves and our children how not to fall for the world's traps? Answers in Genesis is a Christian apologetics ministry that equips Christians to know and defend their faith effectively. Answers in Genesis teaches that the gospel of Jesus Christ depends on the firm foundation of the Bible, starting with the very first verse in the book of Genesis. The book of Genesis provides the groundwork for understanding the world around us and why we even need salvation. Understanding Genesis leads to understanding Jesus. Answers in Genesis offers something for everyone, from creation evidence to gospel training, from comprehensive curricula to witnessing tools to vacation Bible school, which my church used. From books to videos, Answers in Genesis has what you need and a whole lot more. Oh yeah, and Answers in Genesis even has a creation museum with animatronic exhibits that walks you through the whole Bible. you will know how understanding creation is key to everything else. They even have a life-sized Noah's Ark exhibit called the Ark Encounter. What animals did Noah bring on the Ark? How did he fit them all? Prepare to believe. Prepare to save too by going to truthspresso.com/answers and check out their specials on books, DVDs, merchandise, and more. That's truthspresso.com/answers. Since Cohen's testimony is unreliable, the prosecution fails. Blanche mentioned that a lot of Cohen's testimony involved conversations with third parties that weren't witnesses and didn't testify in court. Trump should only be convicted of the charges, he argued, if the records were false and if they were clearly done with intent to defraud. If both aren't clear and obvious, the prosecution fails. Blanche explained that the payments were for a retainer agreement for services rendered. Accounting for payments to a lawyer as legal expenses is common and not a crime. Blanche asked the jury, quote, "How is the government going to ask you to convict President Trump based on the words of Michael Cohen?" unquote. Blanche also argued that if Trump wanted to cover up a crime, why didn't the Trump organization try to destroy documents? Rather, they reported everything to the IRS and that, quote, "it's the way it's supposed to be done," unquote. Trump even submitted the payment records to the Office of Government Ethics. Blanche argued, how can there be an intent to defraud? Blanche also talked about the prosecution's argument that the activities were done in a conspiracy to get Trump elected. He said that every campaign for public office is such a conspiracy because multiple people work together to help one person win an election. The question is only about if anything illegal happened. And since the National Enquirer was primarily the medium in question to keep from publishing the Stormy Daniels story, it would be absurd to think that a story like this in the National Enquirer would determine the outcome of an election. Blanche eventually repeated, quote, "You cannot convict President Trump. You cannot convict President Trump of any crime beyond a reasonable doubt based on the words of Michael Cohen," unquote. So a lot of Todd Blanche's arguments had to do with the integrity of Michael Cohen's testimony. Blanche then showed the jury parts of Cohen's testimony in court that contradicted each other. He also argued that neither the Stormy Daniels story nor the Karen McDougal story was a catch-and-kill tactic, and that McDougal didn't actually want to publish her story with AMI. Blanche brought up his argument in cross-examination that Cohen lied about the phone call with Trump's bodyguard, Schiller, and he showed the AT&T phone records. Blanche once again argued that the entire case of the alleged crime rests on Cohen's testimony and that the jury has no basis to believe Cohen. And once again, since the Stormy Daniels story was already known, just not published in certain venues, it wouldn't have affected the election and would not be election interference. Blanche pointed out that the whole purpose of the Stormy Daniels testimony was to try to bias the jury's view of Trump and distract them from the actual issue of the case. He talked a bit about Cohen's interactions with Robert Costello. Blanche returned again to the prank calls and emphasized that Cohen lied and committed perjury right in front of the jury. He mentioned that Cohen admitted that he stole $60,000 from the Trump organization. He played clips from Cohen's podcast called Mea Culpa, where he blatantly said that the thought of Trump being convicted, quote, "fills me with delight," unquote. He showed a tweet from Cohen that has a picture of a t-shirt with Trump in an orange jumpsuit and behind bars. Blanche gave a summary of 10 reasons that there is reasonable doubt that Trump is guilty of the charges. He then went on a rampage through a list of lies that Cohen told and said that Cohen is the gloat. So if you heard of the GOAT, stands for the greatest of all time. So he said that Cohen is the gloat, the greatest liar of all time. And then Blanche concluded that the verdict should have nothing to do with any jurors' opinions about Trump. Now after this, Judge Mershon got upset that Blanche in his closing arguments said, quote, "You cannot send someone to prison. You cannot convict somebody based upon the words of Michael Cohen," unquote. So at some point, as Blanche would often keep emphasizing, you can't convict someone based on Michael Cohen's words, at some point he said, you cannot send someone to prison. And so the mention of prison, Mershon argued, was, quote, highly inappropriate, unquote. And then the judge and the attorneys met to discuss that. Well, Truthspresso friends, wokeness is everywhere. From kindergarten to elementary school to middle school to high school to higher education in most universities. It's all around us where we shop and where we work. It's even crept into many churches. Romans 12:2 says, "Be not conformed to this world, but be ye transformed by the renewing of your mind." So where can we go to get good, wholesome, encouraging, and in-depth materials to study the Bible and teach ourselves and our children how not to fall for the world's traps? Answers in Genesis is a Christian apologetics ministry that equips Christians to know and defend their faith effectively. Answers in Genesis teaches that the gospel of Jesus Christ depends on the firm foundation of the Bible, starting with the very first verse in the book of Genesis. The book of Genesis provides the groundwork for understanding the world around us and why we even need salvation. Understanding Genesis leads to understanding Jesus. Answers in Genesis offers something for everyone, from creation evidence to gospel training, from comprehensive curricula to witnessing tools to vacation Bible school, which my church used. From books to videos, Answers in Genesis has what you need and a whole lot more. Oh yeah, and Answers in Genesis even has a creation museum with animatronic exhibits that walks you through the whole Bible. You will know how understanding creation is key to everything else. They even have a life-sized Noah's Ark exhibit called the Ark Encounter. What animals did Noah bring on the Ark? How did he fit them all? Prepare to believe. Prepare to save too by going to truthspresso.com/answers and check out their specials on books, DVDs, merchandise, and more. That's truthspresso.com/answers. So now, since Blanche had finished the defense closing arguments, it was time for the prosecution's closing arguments. Joshua Steinglass was the defense attorney giving the prosecution's closing arguments. He addressed the prank call argument by saying that the lack of phone records doesn't disprove an actual phone call because Cohen had multiple phones. He said that the case doesn't rest on Cohen's testimony alone. He said that David Pecker's testimony was reliable and that he's still Trump's friend and has no reason to lie. Steinglass admitted that some witnesses do want a conviction because Trump has lashed at them in social media. He said that the details that Stormy Daniels remembered from Trump's penthouse are credible. Remember the wooden table, the tiled floor, the Pert Plus and Old Spice, and the golden manicure set in Trump's bag. So that was credible, and that those details argue in favor of her testimony being legit. Steinglass said that Cohen has a right to be angry at Trump because he did Trump's dirty work and Trump later snubbed him. He argued that the defense seemed to admit indirectly that Trump knew about the payments to Daniels as they were happening in 2017. Steinglass admitted that Cohen stole from the Trump organization, but that there could be a hole in that claim because of the reimbursements. He noted that Cohen has already paid the penalties for his actions and has been transparent about what he did wrong. And so that points to how Cohen's testimony could be acceptable. Interestingly, Steinglass then acted out a hypothetical version of the disputed phone call with Schiller that also incorporated knowledge of the 14-year-old prankster. So Steinglass basically was responding to Blanche's argument that Cohen lied about calling Schiller and possibly having Trump listen in, talking about the Stormy Daniels affair when logs for that time showed that he was texting with a prank caller. And so Steinglass has acted out a hypothetical phone call that could fit the argument that Cohen realistically could have done all of that in the 90 seconds. He gave a transcript of another phone call record that shows that it's not implausible that Cohen could have talked about the prank calls and the Stormy Daniels situation in a 96-second phone call. Steinglass blamed Trump for some of Cohen's misdeeds, such that loyalty to Trump meant doing his bidding, even if it was unethical or illegal. He said that Trump, quote, corrupted those around him and he got them to lie and cover it up, unquote. He said that there's, quote, a mountain of evidence, unquote, from all the other witnesses to show that Cohen's testimony was true, even if Cohen is known for lying. Costello, Steinglass said, was, quote, a double agent, unquote, to stop Cohen from talking. While Blanche had emphasized that the idea of conspiracy among Trump, Pecker, and Cohen was too much speculation to prove beyond a reasonable doubt, Steinglass said that the meeting in Trump Tower in August 2015, in which those three were involved, is how the jury should view the case, with everything that happened afterwards. Even if the term catch and kill wasn't used, Steinglass argued, the evidence shows that this was the scheme employed to suppress the Daniels and McDougal stories. Steinglass argued that when American Media Incorporated, AMI, paid to buy the stories, they were making, quote, unlawful campaign contributions, unquote. Steinglass then went back to the Karen McDougal story and showed phone records between Cohen and Schiller and from Dylan Howard from the National Enquirer that demonstrated how important the story was to them. Since David Packer said that Trump referred to McDougal as, quote, a nice girl, unquote, unless Pecker was lying too, like Cohen, it shows that Trump was involved in the efforts to cover up that story apart from Cohen's involvement. Steinglass said that McDougal preferring the AMI deal to suppress the story doesn't prove that she didn't ultimately want the story out, but rather because, quote, she wouldn't have to be the next Monica Lewinsky, unquote. Steinglass said that the hush payment to McDougal, quote, is the definition of an unlawful corporate campaign contribution, unquote. Steinglass then played the September 2016 recording of Trump and Cohen talking about $150, meaning $150,000, for McDougal and said that it's, quote, nothing short of jaw-dropping, unquote, and that it's clearly about trying to influence an election. After a break, Steinglass talked about the Access Hollywood tape and that it was what he called a Category 5 hurricane to affect the campaign. He then played a clip of Trump responding to the Access Hollywood tape. Steinglass then went through more call logs between Cohen and the attorney for Stormy Daniels, among others. He said that the payments to Cohen weren't a retainer, but a payoff. Regardless of Trump's concern for family members, the primary reason, given the timeline, Steinglass argued, was to secure an election. Pecker's testimony about Trump being upset about the McDougal story proved he lied about not knowing about the payments. After another break, Steinglass talked about the payments to Cohen in 2017. He said that the prosecution doesn't have to prove that Trump made false business records because the reimbursement payments and the scheme itself is the proof. The business records are falsified because Trump wasn't really reimbursing a lawyer for legal services, but treating Cohen as a funnel for payments to an adult film star. After another break, and yes, there are a lot of breaks here because it was a long session of closing statements, Steinglass talked about the relationship between Trump and Cohen more. He criticized Robert Costello for his conduct in the courtroom. He also caused a brief stir when he read from Cohen's reaction to his own guilty plea back in 2018. After yet another break, Steinglass referenced some of Trump's social media posts to show how Trump treats disloyalty and how he encourages loyalty. He seemed to revisit a lot of details he had addressed to keep key events and conversations in the jury's minds. Steinglass argued that, quote, the evidence as a whole, unquote, proves the case beyond a reasonable doubt. He said that all roads point to Trump and that he's the only one who benefits from all these activities in question. So Steinglass ultimately concluded his closing arguments, and so Todd Blanche, the defense attorney, took about 2.5 hours to give closing arguments, and Joshua Steinglass took about 4 hours and 41 minutes. And when you take into account lunch and then the breaks, it was a longer day in court for the jurors. And so, of course, deliberations would not start that day. The jury had their instructions from Judge Mershon, and they would return the next day, Wednesday, May 29th, to begin deliberation. And so, after all these mind-numbing details that we talked about from the defense, witnesses, and all the craziness that happened there, really to limit the defense's case, and then the closing arguments from first the defense and then the prosecution, which I guess Trump wasn't happy that the prosecution would get the final word on. Then we get into jury deliberations in the next episode of this series. And so I hope that you enjoyed this episode of Truth Espresso, and keep on listening to hear the exciting conclusion with the jury deliberations and the verdict and the aftermath, and God bless.
Thank you for listening to this episode of Truth Espresso. Be sure to subscribe and rate it on your favorite podcast app. Truth Espresso is a member of the Christian podcast community. Check out other great faith-building shows at ChristianPodcastCommunity.org.